Welcome to the Land Department Podcast, the state of land and energy as we see it.
Brent, just how big of a deal is CCS in the industry?
Well, I don't necessarily know how big of a deal it is, but it's here, and it's getting a lot of attention, and you got a lot of different players coming in. So I guess it's yet to be determined. There's a lot that the industry is trying to teach itself and get up to speed on. So, like anything, the coolest thing about land work is you don't know what you're going to do tomorrow. And CCS is definitely one of those things. It's brand new for us, for sure.
Yeah, there's always something new. And because of that, we need to be well educated. We've got someone that's going to help us understand a little bit more about all aspects CCS, renewables, different things in Texas specifically. Brad, welcome to the show.
Thank you guys very much for having me, and I'm happy to be here.
I got to say, the sweetest email handle in all of lawyerdom, oglawyers.com, right there. That's my man.
And I put the G, no G.
Yeah. No, that's pretty awesome, man. I got a good chuckle when the oglawyers.com came out.
That's awesome. So it's Olivia Gibbs, right?
Oliva Gibbs.
Oliva Gibbs. Okay, cool. Yes. My bad. So, tell us a little bit about your firm, what you guys specialize in, the kind of work that you do.
Sure. We are a firm based in Houston, Texas. We focus on all aspects of the upstream oil and gas industry. We particularly do a lot of title and transactional work. We have offices here in Houston. We have an office in Columbus, Ohio. We have an office in Lafayette, Louisiana, and an office in Oklahoma City. We are licensed across basically all major producing jurisdictions, and we're very active in all of them. And we have a very robust upstream practice.
Fantastic.
Yeah, Dudley's interacted with Zach and Brad for years, and as things evolve and the business evolves, they're always very proactive. They do a ton for the industry, particularly the land side of things with continuing education. And Brad spends a ton of time educating, presenting on the latest topics of the day. So I'm excited to have you on, Brad. Thanks for some time, and looking forward to the conversation.
My pleasure.
Yeah, so let's jump right in. You've been doing a lot of education for a while, and as CCS becomes a bigger thing in the industry, as renewables continue to grow in the industry, what are the mistakes that people make when it comes to this land work, some of the title work that's going on?
Sure. We're certainly seeing a lot of conversations arising out of the carbon sequestration side, but a lot of the business that we're seeing right now, a lot of the volume of the business we're seeing right now has to do with accommodation between surface owners and mineral owners. A lot of the places that solar developers in particular are targeting and building their facilities happen to be legacy producing oil areas, which is, a large part of East and West Texas, parts of North Texas, and South Texas. So really all over the state. And depending on where you are, you may run into various complexities identifying who these severed mineral owners are, what rights they may be able to exert over the surface, or what steps they may be able to take to prevent you from developing the surface. There's a case that's been getting a lot of attention that was out of West Texas from the El Paso Court of Appeals. It was called the Midway Solar versus Lyle case. In that case, the court basically stepped through the entire process for kind of analyzing these situations, who is going to have what rights. And it's become more and more apparent that these solar developers in particular are going to need to be very aware of who these mineral owners are and are going to want to get way out front of both identifying and obtaining agreements with these owners on the front end to avoid, long protracted litigation like we saw in the Midway Solar case, and to avoid, kind of the nuclear option of having to even remove their facilities or having to pay somebody for the total value of their mineral estate.
Yeah, and that's that's where the paths cross between us as a broker, between our oil and gas clientele and our, renewables development clientels. And a lot of what we've been doing as, Zach and Brad have been really trying to educate the oil and gas community about, hey, this is what you need to know. We're trying to develop and educate developers on, hey, you need to be thinking about the mineral estate in Texas. This shouldn't be an afterthought. Here's a prime example of what could happen. And, these solar projects take a lot of time to come to fruition. And the mistake has been a lot of people have ignored the minerals, or they were just ignorant to the fact that it was something they had to take care of. The lines are crossing as far as who, educating both sides, and they're starting to interact. And we're going to see it more and more across the country.
Yeah, I think that's a great point. And we've been seeing our oil and gas knowledge get a lot more traction with the developers because of the fact that, like you said, they're just not aware of some of these issues, and they're kind of coming to light on the back end when there's already a lot of sunk cost. And in some of the worst instances, they're having to eat those costs and pick up and move to a different location, realizing that they're not going to be able to get accommodation from the mineral owners, either because they're holdouts or they are, demanding too much money, or in some instances because they maybe can't even be located at all. So there's a number of different issues you might run into.
Yeah, Brad, that might be a good, discussion point. I get asked this question a lot. How much of the mineral interest do I need to get accommodation from? And my answer always is I don't know. Whatever your insurance provider says you need to get. And underwriting is a big thing. And so we see anywhere from 60% to 85, 90% is what they're trying to get. Are you seeing the same?
Yeah, so like you said, I mean, really it's whatever satisfies the underwriters for your title insurance policy. For whatever reason, the magic number that we seem to encounter a lot is right around 75%. But like you said, we're seeing a sliding scale. I mean, obviously, if you can get 100% of the owners to sign off, that would be ideal. As we all know, in many instances, that is not possible. So you want to definitely start with the largest owners first. There's a certain amount of business risk where if the smallest 25% of the ownership is so fractionalized that everybody owns just a very small piece of that remaining 25% in my example, it may not really be worth anybody's time, cost, or effort to try to pursue any type of action against the solar developer. Now, we've seen that scale slide a little bit, like Brent said, from about 65% kind of on the low end up to about 80 or 90% on the high end. But, I wouldn't be surprised to see it sort of settle in at that 65%. One interesting note on that particular number is another hot topic in Texas is the idea of allocation and production sharing agreement wells. It's been sort of judged that if you can get 65% of the owners to sign off on, say, a production sharing agreement for these types of wells, that's enough to get permitted for a PSA well. So I'm not saying that there's any particular significance to that number, but there's at least some precedent there saying that, hey, this is kind of a good lower end of owners that you would want to agree to something like this to kind of minimize the exposure to liability. So, take that with a grain of salt, but just kind of a side note.
Yeah, I mean, like anything in business, it's what's your risk tolerance and what can your economics handle. It's definitely a thing. I mean, I can tell you, gosh, just in our shop in the last 2 weeks, I bet we've been on 6 projects that are mineral title related for a surface development. And I've got 2 presentations scheduled, with clients over the next month to talk about how can you get ahead of this? When can you do, what work can you do early in the process to help steer your decisions in your ultimate surface location while factoring in the minerals without having to spend a fortune. So that's kind of what the industry on the renewables development side is learning. They're getting up to speed on what can I be proactive about? What does that look like? What's it involve? What's the cost associated with it? And things like that. So ever evolving industry, right? Everybody's trying to learn the best way to do things. So fun times for a landman and OG lawyers as well.
Right. I think the answer to that is you should try to start identifying these issues as early as possible. It should really be part of, initially analyzing a potential tract is kind of looking at this mineral title and saying, okay, how chopped up is this? Does the surface owner happen to own any portion of the minerals? By any chance, do they own a majority of the minerals, or do they own nothing at all? And you're dealing with an entirely separate class of unknown owners, just looking at, surface ownership.
Yeah. And I mean, we're doing things as part of our, one-to-one kind of client education on how to navigate the Railroad Commission or any other, regulatory GIS system to determine how much historic production activity has there been. Hell, I scanned a old Tobin map and sent it to a client the other day just so they could have a feel for where activity was historically. And that's a whole new thing to a lot of folks in the solar development world.
And that's a great point, and it's good you're doing that. That was a big part of that Midway Solar case, and the reason that the solar developer, more or less won that case was very specifically because of the fact that there had been very little activity in that particular area. In fact, the tract that was in question in that case had never been leased. There was no plans to lease it. They'd never marketed the minerals. They basically they'd never had any real activity with the minerals at all. And ultimately the courts kind of punted on that case and said, hey, look, how can we determine the value of your minerals if you've never tried to market them in any way? And you've never tried to develop them. You've never really tried to do anything here. So they kind of said, well, your case isn't, yes, they should have sought agreements with you, but your case here wasn't really ripe in the court's opinion for dispute because you'd never tried to use the minerals for any purpose whatsoever. Now, as you can imagine, that's not going to be the case in a lot of areas. There will have been historic leasing. There could even be some production very nearby. The parties could have been approached to lease their minerals, things like that. If any small fact like that had been different in the Midway Solar case, in my opinion, it might have come out very differently. It might have come out the other way against the solar developer. So at the end of the day, that's what, Dudley and a good broker your attorneys should be trying to help you avoid is getting into that situation in the first place.
And is this going to take precedence in other states too? What is happening in some of the other areas that you guys are working, Louisiana, anywhere else in the nation?
So, I mean, you're seeing the same type of analysis in most states. I mean, almost every state has some variation of what's known as the dominant estate theory, which essentially says that the mineral owners are going to have an implied easement or right to use as much of the surface as is reasonably necessary to develop. So what that means is that these mineral owners are going to have kind of a superior right to come on and use the surface to recover the minerals. A lot of states have policies that favor recovering as much of the minerals as possible, not stranding the minerals, things like that. So, every state's going to have some kind of variation on this idea that the minerals might have certain dominant rights and that there's going to have to be an accommodation between the mineral and surface owners. Solar facilities are very surface use intensive. They blanket nearly the entire surface unless you specifically designate a small drilling area somewhere. So that's the reason that covering a parcel of land with a solar facility can essentially destroy all value of the minerals underneath it, at least, kind of from a legal standpoint.
Yeah, you hit on a good point. It's probably a good segue to talk about the actual waiver process or accommodation process, and it's dedicated drill sites. That's clients ask us, what's the best way to go about securing these waivers from the mineral estate, and it's information, right? The more information that we can provide that person, the more information that we can provide to the owner to say, look, we have a plan to accommodate your rights as a mineral owner. Here it is. This is our proposed development. These are our dedicated drill sites within our development. We've done studies of historic production. in and around the area, and these are the methods and means and the spacing that we tend to see, and we've accommodated that. If you can show that as a solar developer, you're making educated decisions, you're accounting for their rights, and not just slapping something in front of them and asking them to sign, throw them a little money. Boy, you can go a long way. And that goes with any negotiation. It's education and thinking that and portraying that you're putting thought into their rights, into their feelings and their value. What are you guys seeing on that end, Brad?
Yeah, no, that's a great point. One of the questions we get from developers quite a bit is there some level of due diligence that we could kind of do on the front end to designate a drilling location, but without necessarily even having to get the mineral owners to sign off on it? It's generally not a good approach because of the fact that it's going to be very difficult to please everyone. And some of the arguments that come up are, well, okay, we're now in the era of horizontal drilling, so there's a lot more flexibility on where you can locate, a drill site or a pad. What happened again in that Midway Solar case is that they didn't confer with the mineral owners at all. They kind of unilaterally chose some areas to put drilling setbacks or drilling islands, but the mineral owners, the Lyles, were able to find an expert witness to come forward and say, okay, look, if you look at the historic trend line, the development in the area, the best place and the best method of producing the minerals under this tract would have been to put a vertical well right smack in the middle of the tract, which is exactly where Midway had already built their solar facility. Now, again, with enough shopping around, you can find an expert witness to testify to just about anything you want. But in this case, they found somebody who was willing to say, you look at the geological data and you look at kind of what's been going on in the area. And basically this solar facility has preempted any possibility of ever developing these minerals because nobody's going to come drill a $10 million horizontal well here. Whether that's true or not, I think it's a little beside the point. What the point is that you've got to get these guys to agree up front to your drilling locations. I think, like Brent said, it shows a lot of, willingness to collaborate, a lot of willingness to work with these guys. If you come forward and say, hey, look, here's a little bit of research we've done up front. We think these might be a couple of good potential drilling sites. Here's why. If you guys are good with this, we'll write you a check. We'll get this signed, and we can all move on down the road and not have to worry about fighting this out in the court system like Midway Solar did.
Yeah, this is really fascinating, and obviously you know your way around it really well, Brad. As far as we've talked a lot about the solar side. On the CCS side, what are some of the things that people need to be aware of that maybe they're not right now?
So CCS, it's kind of a growing area in Texas. There's a lot of talk about it. There's been some permits that have been granted by the EPA. The Railroad Commission has kind of been giving ongoing jurisdiction over these types of wells. And where it's really headed is that, right now, Texas is overhauling its regulatory scheme. They're looking at some things like notice requirements, public comment, a period for public comment on these CCS projects. And they're seeking what's known as permitting primacy. And what that means, it's just kind of a fancy way of saying that the EPA is starting to delegate the permitting process to certain states if they can show that they've built the right regulatory framework to kind of make sure that these CCS projects are being built, appropriately, that the state is doing the right due diligence. And part of that is going to be notice requirements to surface owners, mineral owners, their lessees, in some cases, adjacent owners or lessees. And this is to ensure that everybody's comfortable with either the minerals have been, the mineral reservoir has been depleted to a point that the CCS operations aren't necessarily going to interfere much at this point, or at least to get these guys to kind of sign off. In many cases, you may be injecting the CO2, far below where minerals are being produced. So things like that are being taken into account. And so far, only 2 states, Wyoming and North Dakota, have been actually granted primacy by the EPA, and they've been kind of given their own permitting process. Louisiana, like Texas, is seeking to do that right now. It's been in the past about a 4 or 5 year process to get primacy granted. So we're still in kind of the early stages here. But if the Railroad Commission is kind of able to get control of this permitting process, we really could see these Class 6 CO2 wells, as they're being called, really come into their own in Texas, and this could be a huge area moving forward. And my prediction is that it will be.
Yeah, I mean, as kind of our relationship goes between landmen and attorneys, we tend to see the front end of activity, and it's been a big thing for us and a number of other brokers across the U.S. getting acreage capture, right? And so now the discussions is turning to, okay, how do we go about the permit process? How do we secure our rights? And then now with the Railroad Commission stepping in and starting to talk about notice to mineral estate owners, I mean, it's generating a lot of work for some brokers to determine, who those mineral owners are so you can properly notice them. And it's an evolving thing. I see it depending on your where you're injecting CO2, if it's above or below known producing areas. It could turn into a waiver scenario where you're having to, for your business risk, you've secured, rights from the mineral owners. And so I see in some cases it evolving to that, going beyond notice and to actual, securing waivers from those parties. And a lot of the work we do is given that a lot of our carbon clients are oil and gas based type folks, they're very aware of mineral interest and development rights and things like that. So a lot of the decision making on our part is, what surface owners also own minerals. Let's try to build our project there so that by virtue of securing our carbon leases, we've also minimized our risk on the mineral estate side. And so decisions like that are a big deal. In parts of the country where there's maybe less oil and gas development and less access to 3D seismic, we're doing 3D shoots, to determine, yes, we've done the science, we've done the work, and there are no formations or zones capable of producing hydrocarbons. And therefore you minimize your business risk. So again, it all goes back to, what I said earlier, business risk and good informed decision-making in your land capture, part of the process.
Yeah, and I think an interesting angle that kind of plays into what you were saying is that you've sometimes got these kind of activist plaintiffs attorneys who are out there, and they're talking to some of these mineral owners and saying, hey, look, your minerals probably have no value. They never have historically, and they never will. Suddenly you've got this solar developer with very deep pockets, developing your land. This might be your best chance to squeeze some value out of your minerals. It may be your only chance. So, there could be some other motivations going on here. And I suspect there may have been a little bit of that in that Midway Solar case that I keep talking about, is guys saying, hey, look, nobody's ever going to lease these minerals. Nobody's ever going to drill a well here. This might be our opportunity to kind of squeeze some blood out of this stone. And so just, again, this is just my personal off the record take on things, but something to be aware of.
I would second that take, sir.
Well, and all the more reason to be more diligent, right?
Exactly.
You mentioned that Wyoming and North Dakota already received the permitting primacy, and that Louisiana and Texas are kind of maybe next up in line. What other states might be coming in line? What's that process like? How long does it take? What can we expect there?
I mean, I wouldn't be, as of right now, I'm not aware of any other states that have actually kind of started this application process. That being said, I'm sure that the legislatures of a number of producing states are eyeing this, and we'll probably start to hear from them in the very near future. I wouldn't be surprised if Oklahoma was up next, maybe Ohio, West Virginia, Pennsylvania, some of these states. I mean, they're going to kind of look at the guidelines and the precedent that's been set, and they're going to look at the states that have done this successfully, and they're going to most likely be able to even streamline this process a little bit. And I wouldn't be surprised to see it going faster and faster, and getting, under this sort of 5-year window that we're seeing right now. So yeah, again, I'm not necessarily aware of any other states, but I can almost guarantee that every state with both producing mineral reservoirs and solar development activity are probably, this is part of the conversation at the legislative level.
Yeah, and I guess what I would add to that on the carbon side is you think about refining areas. The Gulf Coast obviously a big source of carbon capture opportunities, but places like the Upper Midwest, ethanol plants, manufacturing in the Upper Midwest is a big thing, and that's where we've seen levels of activity on the acreage capture side of things. So I would expect those states to want to get in line and try to streamline that process as well in the coming months and years.
Absolutely.
Yeah, Brent, we've talked in the past about the value of land brokers and just land men in general to renewables companies. And it seems like that value is only increasing. And you're seeing this really kind of marriage of the oil and gas side and the renewable side needing to come closer together to be able to execute these projects properly. How are you seeing that relationship kind of get closer and closer on both of your sides?
Yeah, I mean, it's you don't know you have a problem until you have a problem kind of thing. And that's what any kind of growing and developing sector of industry experiences, right? And so, frankly, as landmen learn more about the renewables development process, as we learn more about carbon injection, and, we start to see scenarios present themselves, and then we can start thinking proactively. And so that's when you start thinking about, okay, what are the rights of the mineral estate in a given state? What attorneys can I consult with for guidance on how I draft my forms, language that I need to have in my agreements? Things that landmen do early on is, can provide information and consolidate information about, oil and gas development, all the things associated with the land that, someone who's not versed in that just doesn't know to think about. We're starting to see and really pushing a lot with our developer clients about understanding what the underwriting process is going to be like. What can we do on the front end to streamline the title efforts so that the product that goes to the underwriters is complete and comprehensive and provides them with all the information that they need to be able to give you clear guidance on what you need to do for them to issue that policy. And so, frankly, we have a lot of conversations with underwriters as well. I mean, they're clients of ours too. We provide them with abstracts. We talk a lot about what do you need from us? What can we provide to provide a better product, and what can we do for our developer clients to get ahead of things and provide them with information? And so, I mean, that's the season that we're in. It's really a lot of education and conveying to clients what a good attorney can provide you from a value standpoint, what a good land broker can provide you, and what you should be asking and expecting of a good land broker. It's like anything, there's good and bad, and you want to steer people to quality folks that can represent our industry well.
Yeah, I completely agree. I sometimes jokingly refer to these as Boots meets Birkenstocks negotiations, I think one of the value that a good broker familiar with the area really brings to the table is they understand mineral title, which, as Brent can probably attest, many title insurance companies and underwriters don't really know the first thing about oil and gas titles. They don't really understand how it all works, and they quite commonly write those issues out of their policies completely. And so brokers, not only do they understand sort of the title side of things and how to identify the owners, the really good brokers actually know how to go out and find these guys and communicate with the mineral owners. They speak their language. They know how to talk to the mineral owners, how to talk to their lessees, how to kind of encourage them and coax them to enter into these agreements, what they're going to be looking for, so that you're not coming forward with an agreement that's so nefarious that nobody will even entertain it. And we've seen that. We've seen solar developers kind of think that they're dealing with, not to be a little non-PC, some kind of backwoods rubes, where in reality, a lot of these owners are highly sophisticated. They've owned these minerals for years, sometimes for generations. They have a lot of income, from their minerals. They know the value, and they're very wary of anybody approaching them to sign anything, because they've seen every trick in the book. They've been asked to sign sign away every right, they've ever owned at one point or another. And they're cautious and they're smart. And if you know how to approach these people, and you know how to deal with them, you're going to get a lot further than a heavy-handed approach.
Certainly. I mean, it's the art of negotiating, right? It's in the oil and gas space, and any space really. It's, how can everybody walk out of this feeling like they got a fair shake and that they've got a good deal, and that's how you have to go into it. So when it boils down to it, you're dealing with people, and people are proud of what they have, and you have to respect that and do your best you can to educate them, and then but also represent your client and represent the negotiate in your client's best interest. So it's just another land deal, really, when it boils down to it.
Yeah. I love that. Boots meets Birkenstocks. We may title that the title of this episode.
Is this going to be the name of the podcast?
Maybe so. Yeah. You may have influenced us, Brad. Speaking of the boot side of things, you're not just doing renewables law across the nation, but you also in the oil and gas side, obviously. What are some of the trends you're seeing these days on the oil and gas side of your work?
I mean, the trend right now is just that everybody's busy. We're seeing a lot more capital discipline. A lot companies running maybe less rigs, but trying to get a lot more value out of them, drilling more infill type locations, kind of maximizing their value. But with prices, appearing to kind of stick between that $85 to $90 on the oil side and between about $6 and $7. And, with all the forecasts looking for even a rise in prices, maybe a little bit moving into next year, we're seeing activity picking up everywhere from the Permian to the Bakken, and in particular the Utica, the Haynesville, the Marcellus, all of the gassy plays right now are very hot. They're getting a lot less media attention than oil, just because prices at the pump sort of distract everybody's attention. But I think natural gas may be the real unsung hero of development over the next several years. I think the sky is really the limit, and we're going to just see a lot more activity in that space.
Yeah, that echoes what we've been seeing, Khalil, for a number of months. I mean, those are all very active areas for us, and that's where we're focusing a lot of our efforts, a lot of our shifting of our manpower and who we have working what projects and things like that are all centered around the more gassy areas of the country.
Well, this has been fantastic. I've really appreciated your expertise, Brad. Thanks for jumping on with us. We'll have to probably have you on again soon, because these things are constantly changing, and we appreciate having you on. So thanks for your time.
Absolutely. My pleasure. I'd love to do an update edition here sometime in the near future. And again, just thank you guys. It's been a real pleasure.
Thanks again, Brad. Really appreciate it, buddy.
Thanks for listening to The Land Department. Check out our website in the show notes or visit dudley-land.com to learn more about us.